recording the meeting. I'll now take the sediment for this meeting of the Planning and Local Review Body held on 10 October 2022. With apologies from Councillor Ali Callison and Councillor Ross Lambie is attending as a substitute. With apologies from Councillor Jerry Convery. Councillor Mary Donnelly is in attendance. We have apologies from Councillor Gladys Ferguson-Miller and Councillor Grant Ferguson is attending as a substitute. Councillors Mark Horsham, Leslie MacDonald, Richard Nelson and Norman Ray are in attendance. We have apologies from Councillor Dr Ali Salamati and Councillor Graham Scott is also in attendance. Thank you, and I'll pass you back to the Chair for today's business.
Thank you, Stuart. Item 1, any declarations of interest? Item 2, minutes of previous meeting. I'll propose these.
I'll second them.
Thank you. Item 3, review of case in respect of planning application P211210. The applicant is asking the PLRB as a notice of review from Derek Scott Planning on behalf of the firm of Thomas Orr. The applicant is asking the PLRB to review the planning officer's determination to refuse an application for planning permission in principle for the erection of an agricultural workers' dwelling house at land 475 metres south east of Cobo Hall Farm Cottage, Cobo Hall Road, Lanark. The review documents have raised 3 preliminary matters, therefore I'm going to ask the legal advisor to comment on these before we proceed with the review itself. So I'll pass over to Monica just to update us. Thank you.
Thank you, Chair. The first preliminary matter to cover relates to references in the various submissions on the part of the applicant and in the statement of observations by the planning officer, referring to a consultation response from economic development. Although advice was sought from the Council's economic development team by the planning officer, they were not formal consultees and were not required to be consulted under the Town and Country Planning Scotland Act 1997. This is important in relation today in that although their comments are included in the PLRB paperwork, they do not meet the tests to be considered an interested party in terms of the Town and Country Planning, Schemes of Delegation and Local Review Procedure Scotland Regulations 2013. Consequently, Economic Development have not been requested to submit further representations to the review today. Their original advice to the Planning Authority is, however, before the PLRB, and it is within the PLRB's gift to seek further information from Economic Development if they consider it necessary to enable them to make a decision today. To do that, the PLRB would need to issue a procedure notice, and anyone issued with the procedure notice would have the opportunity to respond to any written submission lodged. This is something that the PLRB can consider as normal when it considers whether or not further procedure is required for it to make a decision today. Oh, sorry. Apologies. The second preliminary matter to cover is to advise members today that accompanying the notice of review is a letter from SAC Consulting dated 15th of June 2022. It is numbered document T06 and begins on page 183 of your papers. The statement of observations from the planning officer on the applicant's notice of review, paragraph 3, page 91, refers to this letter as new information which should not be considered by the PLRB. As members will be very well aware, section 43B of the 1997 Act prohibits the raising in a review of new matters that were not before the original decision maker, unless it could not have been raised before or there are exceptional circumstances which prevented it from being raised before. What constitutes a new matter isn't defined in the Act or accompanying regulations. However, Scottish Government guidance, notes to reporters, in particular GN 16, states, reporters should interpret a new matter as a new issue or topic that was not before the Planning Authority. This is the advice that is given to reporters in Scottish Ministers' appeals, and it's generally considered that the same approach should apply to local review bodies. Consequently, a new matter is more than just new documents or information. The advice from the Scottish Government implies that if an issue to which the information relates was before the original decision maker, it is still admissible. In relation to the matter before the PLRB today, although the letter was not submitted prior to the determination of the planning application by the planning officer did request information from a suitable body like SAC as part of the process. Therefore, it was an issue before the planning authority. The first matter for members to determine today, therefore, is whether or not to take into account the letter from SAC Consulting in their determination today. The final matter to raise as a preliminary matter is a representation from a Mr Jim Russell of Cobble Hall Farm that was received late on the 6th of October 2022. In terms of the regulations, this representation is out with the timescale within which representation is required to be received by interested parties. Mr Russell submits he's an interested party on the basis that he objected to the original application in the name of his company, D&M Russell, and that can be found on page 49 of your papers. Mr Russell has been advised that this representation is late, but has asked that its submission still be accepted by the PLRB because it raises relevant material considerations that should be considered by the PLRB. Despite the timescales provided by the regulations, the 1997 Act requires that all relevant material planning considerations are taken into account when planning decisions are made. It is my advice and that of the planning advisor that the representation does raise a material planning consideration in bullet point 3. Therefore, the second decision for the PLRB today is whether to take into account this late representation. If the late representation is allowed in, although late, the PLRB will also wish to consider whether the applicant should be allowed an opportunity to respond to this representation, or whether his submissions to date cover this issue, and therefore no further procedure is required. Again, this is something that the PLRB can consider as normal when it considers whether or not further procedure is required for it to make a decision today. I believe the late representation will be distributed now for the PLRB members to consider. Thank you.
Thank you, Monica. Firstly, can I just check that all members have received the email? If you haven't, can you just indicate? Thank you. So it looks like all the members have received the further representation. The review documents have raised 3 preliminary matters, and prior to proceeding any further to the PLRB, we have to consider and decide whether or not we are happy to take into account the letter from the SAC Consulting submitted with the notice of review Having heard the advice from the legal advisor, it is, in my view, that even although the letter from the SEC Consulting itself was not available to the officer at the time of determining the planning application, the issue of whether the erection of an agricultural workers' dwelling house at this location could be justified in the terms of existing enterprise is a matter that was before the planning officer. In addition, planning services had the opportunity to respond to this new information in the planning authority's response to the notice of review. Therefore, this new information, in my opinion, can be taken into account into the PLR's determination today. Do you all agree?
Agreed.
Agreed. Anybody otherwise minded? The PLRB also has to decide whether or not to allow the additional representation received on the 6th of October from Mr Jim Russell. And it is in my view that it does raise material planning considerations and that we should accept the representation, although I do have some concerns about the late submission. And on this occasion, I do think that it does raise these material planning considerations, but it's not a norm for this PLRB to accept late considerations unless they have that planning consideration. Do you all agree?
Agreed.
Anyway, otherwise minded? Thank you. I'm going to ask the planning advisor to describe the background to this request for a review to the members. James?
Thank you, Chair. This local review relates to the refusal of an application for planning permission in principle for the erection of an agricultural workers' dwelling house at land approximately 475 metres south-east of Cobblehaw Farm Cottage, Cobblehaw Road, Lanark. The site is located on land designated as rural, as defined in the adopted South Lanarkshire Local Development Plan 2. The site is bounded to the north, south and west by agricultural fields and the River Clyde to the east. The site includes the ruins of the demolished Hindford Mill Cottage and its associated farm buildings and is accessed via a private farm track. The site is located within the working land of Charleston Park Farm, with the existing farmhouse and farm buildings located approximately 1,000 metres to the northwest of the site. Whilst the development has not yet commenced on site, within the boundary of the application site are two extant planning permissions for agricultural buildings. Both were granted planning permission through agricultural prior notification. The indicative location of the proposed dwelling house is located on the footprint of the smaller of these two permissions. The larger of the permissions relate to the erection of an agricultural compound, mainly for use in relation to sheep rearing. The proposed dwelling house is intended to be associated with this permission if implemented. As the application is for planning permission in principle, the assessment is of the principle of the development only. Matters relating to design are therefore not part of the required assessment process. As noted in the agenda papers, 6 letters of objection were received following neighbour notification and advertisement of the application in the local paper. The concerns related to road safety, the retired farmer continuing to live on the farm, creating a potential steading development, lack of power to the site, the farm being mainly a crop farm and an associated haulage business, lack of information in relation to the business need for the proposals, no flood risk assessment being submitted, dwelling houses are not agricultural permitted development, and the proposals are contrary to the development plan. In terms of consultation, there were 2 consultations requested. The first was to Roads Development Management, who had no objections to the proposals, subject to conditions relating to provision of adequate parking on site and passing places being installed along Cobblehaw Road from the junction of the A70. The second was to West of Scotland Archaeological Service, who had no objections, subject to a condition requiring a programme of archaeological works being attached to any permission if granted. In assessing this local review, the local review body are respectfully requested to consider the following relevant policies of the South Lanarkshire Local Development Plan 2, which are Policy 4, Greenbelt and Rural Area. This policy advises that within the rural area, the Council seeks to protect the amenity of the countryside while at the same time supporting small-scale development in the right places that is appropriate in land use terms and is of high environmental quality that will support the needs of communities. It also notes the rural area functions primarily for agriculture, forestry, recreation and other uses appropriate to the countryside. Development which does not require to locate in the countryside will be expected to be accommodated within the settlements identified on the proposal's map. Isolated and sporadic development will not be supported. Then Policy 14, Natural and Historic Environment. This policy states that the Council will assess all development proposals in terms of their impact on the natural and historic environment, including biodiversity, geodiversity, landscape and townscape. It also further states that the Council will seek to protect important natural and historic sites and features from adverse impacts resulting from development, including cumulative impacts. And then Policy GBRA1, Rural Design and Development. This policy states that within the rural area, all proposed developments require to adhere to a set of criteria. There are 7 criteria within this policy, and they are as follows. 1. Developments shall be sited in a manner that respects existing built form, landform and local landscape setting. Proposed developments shall be well related to locally traditional patterns of scale and shall avoid the introduction of suburban-style developments into the rural environment. Proposals specifically for residential development should not be isolated or sporadic. 3. Proposals shall be of a high quality, of either traditional or contemporary innovative design which interprets and adapts traditional principles and features. 4. Proposals shall make use of appropriate materials which respect and reinforce local character and identity. 5. Developments shall have no unacceptable adverse impacts on existing residential amenity, particularly in terms of overlooking or overshadowing of existing residential properties. 6. Proposals relating to residential development, including extensions and alterations, shall conform to the requirements of the Council's Residential Design Guide and, in particular, shall ensure the provision of appropriate private amenity space to all existing and proposed residential properties. 7. Development proposals shall incorporate suitable boundary treatment and landscaping proposals to minimise the visual impact of the development on the surrounding landscape. Existing trees, woodland and boundary features such as beech and hawthorn hedgerows and stone dykes shall be retained on site. A landscape framework shall be provided, where appropriate, to demonstrate how the development would fit into the landscape and improve the overall appearance of the site. And finally, we have policy GBRA 10, which states that within the green belt and rural area, the provision of a dwelling house or temporary accommodation may be considered in association with a rural business. Proposals will be required to meet the following criteria. A, for all proposals. 1. The applicant should first consider whether there are traditional buildings suitable for conversion, redundant buildings, gap sites, or opportunities to consolidate a building group within the land available to them. 2. The business proposal shall comply with policy GBRA 2. 3. It is demonstrated that accommodation is essential for the successful management of the business. 4. It is demonstrated that the business, new, relocating or established, is based upon a robust market assessment, planned on a sound financial basis, and the business will become viable in the long term. 5. The submission of a 5-year business plan will be required to demonstrate compliance with criteria 3 and 4. 6. The accommodation shall meet rural design policy as set out in policy GBRA 1 and in supporting planning guidance. B, for established businesses. For established businesses, a permanent dwelling shall be considered subject to the following criteria. 1. Evidence is provided to demonstrate the business has been trading at the proposed location for at least 2 years. For businesses relocating from an existing countryside location, the submitted business plan shall demonstrate why the relocation is required and that the business would continue to be profitable. 2. If the proposed dwelling house is located in an isolated position and the business use is the only justification for this siting, an occupancy condition will normally be attached to any permission granted. 3. The new dwelling shall be commensurate with the functional requirement of the business. C, for proposed businesses. For businesses which are proposed or cannot yet demonstrate profitability for the preceding 2 years, temporary accommodation shall be considered subject to the following criteria. 1. For the first 2 years, only temporary accommodation will be permitted. 2. After 2 years, it can be demonstrated that the business is currently profitable and projected to remain so for a further 2 years. Then a proposal for a permanent dwelling shall be considered. This should comply with the above criteria for established businesses. If it cannot be demonstrated that the business is currently profitable, then an extension to the time period for the temporary accommodation shall be considered. This will be subject to the submission of a revised business plan, which shows that the business can become viable. The Council will require the removal of any temporary accommodation where the business has failed to develop successfully or within 6 weeks of either the expiry of the permission or the occupation of any subsequent permanent dwelling granted permission. So it's these policies that provide the development plan basis for considering the application. Finally, Chair, the review body should note that the appellant has not requested any other procedure other than a review of the written documents submitted. Thank you.
Thank you, James. The next point for the PLRB to consider and decide is how to proceed with this review. The applicant's agent has indicated that they are content for the review to proceed on the basis of review documents only, with no further procedure. Taking account of what is in our papers here today, we have to decide if they do in fact contain sufficient information for us to determine the review today, or if we need more written information, a hearing or a site visit. I think that all the information that we have, plus the detailed photographs we have of the site, does provide us with all we need to consider this review without either a site visit, hearing or further written submissions. Any comments? Councillor MacDonald.
Thanks, Chair. Given the mention of a previous building being on site, I would like to propose that we carry out a site visit to this location.
Thank you, Councillor MacDonald. I'm looking for a seconder for Councillor MacDonald for a site visit. No. Sorry, Councillor MacDonald. No, nobody has came forward for a... Oh, sorry, Councillor Donnelly. Hang on a second. Councillor Donnelly.
I'll second that proposal.
Thank you. Councillor Donnelly. Can I ask for a seconder for my original motion to go forward that we carry forward with the review today? MD to second that. Councillor Norman Ray.
I will second that.
Thank you, Councillor Ray. Thank you. I'm going to ask Stuart just to come in and go through the procedural. If you just bear with us, we're just having some technical issues just to allow you to vote, which should come up on your screen in front of you if you're in the chamber, or on your laptop if you're at home. So just bear with us just for a second.
Okay, sorry everyone, just a wee...
Thank you, and apologies for the technical issues that we have just experienced. We are hopefully back up and running now, and we're back online. Stuart is going to just run through what happened just before we cut off with the motion and the amendment, and to make sure that everybody who was in the meeting prior to the technical issue are now back in. Stuart.
Thanks, Chair. Just to clarify, first of all, before I move to the vote, that all members that were earlier present are now back in the meeting. So we were about to take a vote. The motion proposed by Councillor Nelson, seconded by Councillor Ray, is that the review proceeds without a site visit, hearing or additional information. And the amendment proposed by Councillor MacDonald and seconded by Councillor Donnelly is that a site visit be carried out as part of the review. The vote is now live, and I would ask that members please select your voting preference. Okay, I've now closed the vote and can confirm I'm not aware of any further technical issues. 6 members have voted in favour of the motion and 2 members have voted in favour of the amendment. I therefore declare the motion carried. Thank you.
Thank you, Stuart. We can now move forward with the decision. Can I summarise the points made? The application is for planning permission in principle for the erection of an agricultural workers' dwelling house at land 475 metres south east of Coble Hill Farm Cottage, Coble Hill Road, Lanark. The adopted South Lanarkshire Local Development Plan 2 identifies the site as being within the designated rural area. If we consider that there is no valid policy justification to support the proposed dwelling house at this location, and it would not accord with policies 4, 14, GBRA 1 and GBRA 10 of the adopted South Lanarkshire Local Development Plan 2, permission can be refused. Or, if we consider that there is adequate justification for the location of the proposed dwelling house, we could grant planning consent subject to conditions. Our options here today are uphold or reverse or vary the planning determination. Can I invite any decisions or questions? Councillor Lambie.
Hi, Chair. Thanks. Just going back to basics a little bit on this one, because it seems to have got very complicated, especially in relation to the business plan aspect of it. So, if my assumptions are right, there was a historical building on the site. I can see a historical map in the submitted papers, and there was a collection of buildings on that precise site. And the proposed dwelling is going to sit on roughly the same area footprint of a previous dwelling, and then the farm buildings, agricultural buildings, are going to sit in agricultural land adjacent to that. So it seems to me, in terms of building uses on the site, it seems fairly sensible to have a dwelling on the footprint of an old dwelling. And we can see from the map, the dotted line of the part of the field which isn't currently being worked and tilled, and that obviously the footings and foundations of that old dwelling are still in there and preventing it from being farmed. So it seems potentially appropriate to put a dwelling back on that site, and it seems also appropriate to have agricultural buildings on agricultural land. And obviously there's existing access roads to that former dwelling location. So in terms of the reasons for refusal, 01 and 02 are kind of suggesting that it's not an appropriate form of development, etc., despite that having been the case in the past. So it seems a little bit harsh to me, 01 and 02. The reason for refusal number 4, the precedent. Well, the precedent this application would be setting is a new dwelling on the footprint of an old dwelling and agricultural buildings and agricultural land. So that doesn't seem to me to be a dangerous precedent to set. But I would like a little bit of clarification maybe on reason for refusal number 5, the historic sort of environment one. Is that related to archaeological worries, or is it about affecting the setting of the other sort of ruinous mill building adjacent? If we could have a little bit of clarity on that, would be helpful.
Thank you, Councillor Lambie. I'll ask James to see if he can clarify any points for you in your question.
Thank you, Chair. Just, I suppose the only clarification I can provide as advisor would just be in reason 5, the refusal reason 5. The officer states that policy 14, natural and historic environment, as we've stated, does assess all development proposals in terms of their impact on the natural and historic environment, including landscape. Now, in this situation, the application site is within a special landscape area, and therefore the planning officer in reason 5 is suggesting that it's contrary to policy 14 in terms of landscape because of where it would be located. But I'm afraid I couldn't provide any further advice on the actual refusal reason.
Monica, you want to come in? Monica, I'll let you just come in just as well.
Sorry, yeah, it was just to refer Councillor Lambie perhaps to paragraph 3.3 of the officer's report, assessment and conclusions. There's a bit more information there in relation to the assessment in relation to policy 14, if that assists.
Thank you. Councillor Lambie? Supplementary?
Yeah, just to say thanks for that. I'll have a quick second read of that. But I'm aware also that there was a previous permission for a agricultural building of X size and volume and proportion on the site. So I'm just wondering how that was acceptable and this new one's not acceptable. And the only difference seems to be a different type of use from agricultural to domestic. So the impact on the visual landscape is there's parity between the two things. So I'll let other committee members come in with some questions whilst I just have a quick double read of that paragraph. Thanks.
Thank you. Councillor Graham Scott. Councillor Scott.
Thank you, Chair. Can you hear me?
Yes, can hear you.
I know we've had technical problems, but I'm glad you can hear me. My first point is very similar to Councillor Lambie's in the fact that the specific point of a Hindford Mill cottage was on that site. So there is a precedent, to use a word, of a cottage of I presume, agricultural workers building on that site. So, as I say, again, that's where the term precedent. The broader point I want to make is, and I hate using the term in my day in planning, but I'll use it in my day in planning, where there was a bona fide working farm and there was a request to have an agricultural building for a worker or for staff to support that farm, and it was a bona fide working farm, we usually allowed it because, and again, James can tell me, one of the tenets of planning is that we support economic development in a rural area, and obviously a working farm has a strong economic reason to exist and has a strong economic reason for operating, and it helps a broader community. That's the point I want to make. Another broader point is, again, We've had tied cottages in Scottish agriculture going back at least 300 years. And again, modern planning has always taken that into account, that where there is a working farm, you will have workers attached to it. And the point James mentioned about the distance, going back again historically, there's always been the farm owner never wanted his workers in a sort of modern day sort of corral or compound. The farm cottages were usually a bit distant on the land, but a bit distant from where the owner and the main buildings of the farm. So the distance bit, I don't think is a problem. Again, I've got concerns about this. Again, if James can answer some of the points, that it's a bona fide working farm. There's a reason for this agricultural workers cottage or house to be on it. And if James can make some comments, obviously I'll be interested in his reply. Thank you, Chair.
Thank you, Councillor Scott. James, do you want to come in any of that? Councillor Scott.
Thank you, Chair. I suppose mainly just to clarify, I don't think even the original planning officer is the site does relate to a large-scale working farm. In terms of the supporting of rural businesses, I mean the policies that we did refer to are to, if appropriate, support rural businesses within the rural area to support economic development. And finally, the issue is there is planning permission on the site for 2 agricultural buildings. Neither have been implemented yet, so whilst both permissions exist, they haven't actually commenced development. Thank you.
Thank you. Councillor Scott, was you any supplementary to that? No. Thank you. Councillor Normanry.
Thanks, Chair. I was just looking for a bit of clarification on various issues seem to have been raised by objectors and so on to do with whether electricity supply could be provided, and in terms of the passing places that had been discussed on the access road and over land ownership rights to put these kind of things in place. I was just wondering whether that's actually a relevant consideration in terms of the planning application, or whether that would be a legal issue that would have to be resolved between the developer and any landowners at a later date.
James?
Yes, thank you, Chair. Just to confirm, yes, if planning permission is granted, it's then up to the applicant to make sure that they can comply with any planning permission and the conditions, which in this instance could be those passing places, and they would have to then speak to the landowner of where the passing places are, but that would be separate to the actual planning decision. And again, with electricity supply, if planning permission were granted, it's then up to the applicant to spend the infrastructure costs to bring electricity into the house to make it habitable. But that, again, would be post any decision made.
Okay, thank you.
Thank you, Councillor Ray. Any further comments? No. Councillor Lambie.
Hi there, thanks, Chair. Yeah, just looking at the documents submitted, I can see that there was a building approved for the same site, an agricultural building. So the acceptability of development in that landscape has been confirmed by the planning department. You know, it's not out of bounds to be building built form in that location. So that kind of passes that test in my mind. So at the minute, I'm thinking it is an appropriate type of development in terms of land use, because it's a dwelling on top of the old footprint of our previous dwelling. It's agricultural buildings on the agricultural part of the land. I can't see the reason for refusal number 4 setting a precedent. I can't see the danger in that. And I could see how conditions could be put with a particular, conditions could be applied to a permission, which would prevent the conversion of the agricultural buildings into dwellings at a later date. I'm sure there must be some way of stopping this becoming a development which starts to spread or get larger. As you know, Chair, this is my first PLRB meeting. I'm standing in for another councillor that couldn't make it. So I'm not quite sure the procedure, but I'm kind of minded that we do. That I'm leaning towards recommending it or asking for it to be approved, but it would be on the basis of seeing conditions that sort of allay some of the fears of the objectors. So I'm not quite sure the procedure of if I put a motion forward or do we have to request the planning department to tell us if they were to approve it, what their conditions would be? If you could give me a bit of advice, thanks.
Yeah, thank you, Councillor Lambie. So you are more entitled to put forward any motion or amendment to anything that is put forward. If the motion is to grant the planning permission, then we will adjourn for a short period of time that the draft conditions be issued to the members for them to look over, and then we will come back in just to close everything off to make sure it's tidied up. So I'm just going to check with yourself if you are putting forward a motion that we grant this planning permission and the grounds for that planning permission.
Yeah, thanks, Chair. I think I will propose a motion that we approve this application on the condition that we see from the planning department some proposed conditions that will prevent the spread of development, prevent agricultural buildings being converted into dwellings in the future, and if there needs to be an archaeological condition, etc. I just feel that there's a very long and strong history of small holdings in rural Lanarkshire, and this being the site of a former one, it feels overly draconian for us to be refusing this on some very minor technical grounds regarding the business plan and things like that. So yeah, in summary, I'd like to propose a motion to approve. Thanks.
Thank you, Councillor Lambie. I was looking for MD to second Councillor Lambie's motion to approve this planning. Councillor Scott. Sorry.
That's okay.
Thank you, Chair. I will second Councillor Lambie's motion. I think it's an excellent motion. I think it touches all the buttons in relation to the problems of the original decision, and I'm quite happy to second and also have a look at the conditions that will come from planning.
Thank you, Councillor Scott. We will, hopefully, if this is minded by everyone, then we'll send round the draft conditions that will go with the planning application, the planning consent. Have we any further motions, any further amendments? Now we have the motion. No, I'm just going to ask Stuart just to clarify the motion.
Yeah, thanks, Chair. So just to clarify that planning permission be approved subject to conditions on the grounds that is an appropriate type of development in terms of land use. Is that a fair reflection, Councillor Lambie, of the grounds?
Yes, thanks.
Thank you.
Okay. Yep. Nobody else otherwise minded?
Nobody else is otherwise minded. Okay, we are going to adjourn to 11:55. I'm going to ask that the draft conditions are sent out to all members present. If we can come back at 11:55, just to sign off on those draft conditions, and then we'll tie up today's meeting. So 11:55, thank you. Councillor Donnelly. Donald, I think. Thank you. Welcome back, members, to the PLRB. I do hope everybody has the chance to look at the draft conditions. Is there any comments or Councillor Lambie?
Hi, it's me again. Apologies for monopolising the microphone. I've read through the conditions. They're all read pretty good. I can see the archaeological one. I can see the passing place one, etc. The only one I was thinking, I'm not sure if we can do it, but is it possible to remove permitted development rights just to prevent any future sheds going up without planning consent? Thanks.
James?
Yes, thank you, Chair. Normally, we don't like removing permitted developments unless there's a reason. But again, given the landscape concerns and the location, it could be considered that it's appropriate to remove permitted development to minimise any suburban clutter that could be associated with house extensions, etc., without further planning applications.
Thank you. I'll bring Councillor Lambie just back in before I get Councillor Scott, if that's okay.
Yeah, thanks. I mean, I think it would be a really good condition to add. Like the officer says, it would just stop the spread of domestic sheds and any other, because the permitted developments rights are quite expansive, especially when you're in open ground areas like this. So you could end up with quite large sheds of certain heights and volumes without any planning permission. So I think it might be a really good condition to add if other committee members are minded to agree.
Thank you, Councillor Lambie. I'll bring in Councillor Scott.
Thank you, Chair. Very similar point to Councillor Lambie. And this is probably more of a point for Monica than for James, but to give the objectors some comfort, would there be a proviso, or could there be a proviso put in about any on sale of the house, in terms of if it ceases to become a working farm or whatever, that it can't be sold on while it's still a working farm?
Thank you, Councillor Scott. I think that may come under condition number 3, but I'll just ask Monica just to come in on that.
Thank you. Hi, Councillor Scott. Yeah, condition 3 is as the chair has referenced, is probably as far as we can go in that regard. We wouldn't be able to. I think anything further than that wouldn't be reasonable, and therefore wouldn't meet the test for a legally competent planning condition. However, that does restrict the occupancy of the property to an agricultural worker, and obviously is there, but in terms of putting anything on the title to a property, and many years ago we would be able to do that by Section 75 agreement, but the Scottish Government guidance nowadays says that that's not appropriate or reasonable. Therefore, I think really that's as far as we can go in that regard. Thank you.
Okay, thank you, Chair.
Thank you, Councillor Scott. So we do have a further comment from Councillor Lambie in that the permitted development rights are removed. Is everybody happy with that? Is there any comments? Are we happy to add that in?
Agreed.
Agreed. Okay, thank you. Okay, therefore it's a decision of the PLRB to grant planning permission subject to the conditions that we have just agreed. The next stage is that a written decision notice will be issued by the PLRB, and this should be issued within 28 days. Agenda item number 4 is urgent items of business. I have no items of urgent business, and thank you very much for attending and for your for staying with us during the technical issues we had this morning. Thank you.